Hi, I am Richard Oehler, retired family doctor. Today I will address corruption of our legal system. Before starting this presentation, I would like to again state that I know many fine attorneys as personal friends and acquaintances, but the lawyers and judges so far involved in this case have shown themselves to be either corrupt or so ignorant, incompetent, and negligent that corruption of the legal process is the result. Our legal system has been established over the 200 years of U.S. history. It is based on the assumption that truth will be told by the officers of the court, so trial by jury has real meaning. When the jury is presented with lies by the prosecution, justice, fairness, integrity, and honor are sacrificed. In the abuse case of Keith McMullin, this is exactly what happened. This case was decided on the basis of several lies, all by the prosecution, with no objections by the defense attorney, who actually asked an experienced medical witness to lie as he testified, or she would not call him. I was that witness, and I was not called. Lie number 1. The prosecuting attorney, Stacy Goodman, stated in her opening statement that there is no physical evidence. The accuser was examined and found to have a normal hymen. This is physical evidence. How can all three highly trained legal officers of the court not recognize this obvious fact? It was stated that testimony is evidence. The only way to disprove evidence is by other evidence. It was agreed by the judge and both attorneys that no evidence, in other words testimony, would be allowed by McMullin's witnesses, who had known both he and his accuser for years. She was known by many to lie. He was a man known for his integrity. Lie number 2. The prosecution's medical expert, Christine Smith, stated that she was as qualified as an MD to do this job. Great emphasis was concentrated on the fact that Smith had a nurse's license allowing her to prescribe drugs, diagnose, and treat patients. No emphasis was made of the fact that she had little or no training as a gynecologist. This case was decided on the basis of a gynecologic exam. The Daubert rule emphasizes that only qualified people should be allowed to testify in court as expert witnesses. Oregon apparently does not follow this rule, allowing anyone to claim to be an expert. Smith then proceeded to state lies 3 and 4, which are so medically stupid that no MD or DO would testify to their truth, or they could lose their license to practice medicine. Her own testimony proved she is not an expert. Lie number 3. Smith testified that pregnancy proves sexual penetration. Lie number 4. Smith also testified that she expected to find a normal hymen in all cases where sexual penetration had occurred 2 to 3 times per week for 18 months. She based her opinion on the Kellogg study. This is the same Nancy Kellogg, MD, who is having her false testimony exposed as several cases are overturned, but only after her innocent victims spent 15 years in prison. I am not sure Miss Smith even understood the study, which stated that those girls examined within 2 weeks of the last sexual penetration were not normal. Read the study. If Smith is an expert as qualified as an MD, she also had to know about several studies which contradicted her opinion. Lie number 5. Prosecuting attorney Stacy Goodman stated in closing that this whole hymen business is a myth. All sexually active teenagers have normal hymens because, ladies and gentlemen of the jury, we are designed to have sex with each other. Stop and think. This trial has just proclaimed a new medical fact contradicting what any family doctor or gynecologist has known and seen in the examination room for over 100 years. Excuse me. Smith and Goodman have just stated as a true fact that all women going into labor for the first time have normal hymens. Lie number 6. Heather Karabika asked me to commit perjury. I was apparently the only person involved in this trial who had any experience reading and understanding a medical study, as well as the only person who had performed a couple of thousand pelvic exams. Lie number 7. Judge Jeffrey Jones complimented the lawyers on their professionalism during this trial. Either corruption or ignorance, incompetence, and negligence must be the basis of professionalism in the courtroom for this to be a true statement. I would ask Judge Jones to explain how a jury of untrained laymen can use lies to reach a fair verdict for both the accused and the accuser. Trial by jury of our peers sounds great, but it only works if the prosecution does not lie. Let's next look at the conduct of the officers of this court and the other judges and lawyers involved who take an oath to see that true justice is done in our court and legal system. Judge Jeffrey Jones. 1. This experienced judge decided that a 10-2 decision would be adequate to kill a person in prison when the only evidence is the word of the accuser, who was a known liar by her family, peers, and many adults who had known her most of her life. 48 of our 50 states require a unanimous verdict when the felony is of this magnitude, requiring death or a very long sentence. The verdict was 10-2 in this case. 2. This same judge allowed a medically unqualified person to testify falsely about the case and decided with the prosecuting and defense attorneys that no witness would be allowed to testify who disagreed with the lies told by the accuser. 3. The judge condoned vouching by prosecution witnesses. 4. The judge did not delay his sentencing when he had over 30 people writing to him about their concerns over the courtroom lying. 5. Why did he not delay his sentencing while he or his staff could check the perjury committed by the state's expert witness in his courtroom? He was informed by this medical doctor before sentencing that the charge was medically impossible. 6. Why did this judge and the 2 attorneys decide before the trial began that no witnesses who knew the accuser and the accused for years would be allowed to testify concerning their reputation for telling the truth? He did allow persons who had visited with the accuser for 15 to 60 minutes to vouch for the truth of her statements. 7. Why did the judge not insist that people on the jury be able to hear the testimony being presented? There were at least 29 requests that witnesses speak up so that people in the courtroom could hear. Defense attorney Heather Karabika. 1. Before trial, Ms. Karabika arrogantly refused the advice of an experienced defense attorney in the presence of her client, stating that I'm now his attorney and don't need your advice. 2. At least one other attorney offered advice which appears to have been ignored also. 3. The case rested upon the testimony of the state's medical expert, who is woefully unqualified to be testifying about gynecology. Ms. Karabika made no real attempt to question her credentials as an expert, nor question her about the study by Nancy Kellogg, MD, upon which the expert based her opinion. The study was never introduced as evidence, but if read and studied would have exonerated McMullin. This is the same Nancy Kellogg who has testified falsely in several cases, which are now being reversed, but only after years of incarceration by the innocent victims of her false testimony. 4. No qualified medical expert was called to refute the perjury by the state's unqualified expert. 5. No objection was ever raised to the vouching by the state witnesses. 6. No questions were ever asked the expert about several medical studies which would have confirmed McMullin's innocence and directly contradicted the opinion of the unqualified medical expert. 7. Before I was to be called as a witness, Ms. Karabika met with me in the hallway outside the courtroom and told me if I would not promise to answer only the questions she asked, she would not call me as a witness. I told her I would be under oath to tell the truth and would not lie on the stand by withholding medical facts that proved McMullin was innocent. She did not call me. 8. Karabika was appointed a circuit court judge by Governor Kitzhaber shortly after this trial from a list of 19 candidates. Was she really focused on her innocent client, or was she more focused on becoming a judge and did not want to appear soft on crime? Her performance strongly suggests she threw her client under the bus in order to further her own selfish goals. If she did not, she is so incompetent and negligent, she has no business sitting as a judge or even holding a law license. The DA's office and Stacy Goodman, the prosecuting attorney. 1, someone lied to the grand jury to get an indictment. Number 2, Goodman lied to the jury about evidence during the trial. Number 3, Goodman used vouching during the trial as a mainstay of the prosecution's case. Number 4, the DA and Goodman ignored medical studies which were readily available to these attorneys before trial, which proved the accuser and their medical expert both lied. Number 5, a medically unqualified expert was used to convict an innocent man. Now, the appeals process lawyers and judges. 1, the reviewing attorney also ignored medical studies. 2, the reviewing attorney also falsely stated that an MD had made the perjured statements by Christine Smith, a nurse practitioner, which might make these statements seem more credible to the panel of reviewing judges. 3, the panel of judges also ignored medical facts and rubber-stamped the trial court verdict with no apparent independent judgment or common sense employed. Number 4, Attorney General Ellen Rosenblum also rubber-stamped the trial court decision with no apparent independent judgment or common sense employed either. She had told me that she had no control over the circuit court performance. However, she affirmed their decision. The Oregon Bar and Committee on Judicial Fitness claim no responsibility to investigate or act in any way to correct such basic disregard for our rights as citizens to a fair trial. Apparently, perjury and misconduct by officers of the court is considered normal behavior by these bodies, which are supposed to protect the integrity of our court system. Their inaction appears to support the commonly held idea that LIAR is just another way to spell lawyer. At this point in time, not one lawyer has exhibited any degree of concern for the rights of Keith McMullin. He continues to sit in prison, approaching 3 years, while valuable state resources are wasted holding him in prison. The criminal misconduct or complete ignorance and negligence by our judicial system officers continues unchecked. Anyone accused of a sex crime in Oregon, and probably nationally, has a good chance of being falsely convicted. Foster parents and adoptive parents are at great risk, as are many others who deal with children. If McMullin is an example, DHS will immediately believe an accusation, even though they have extensive files on you. Thank you for your kind attention. Now go ask the media why they show no interest to investigate this type of miscarriage of justice. Deflating a football claims headlines for weeks, but our judges and lawyers throwing an innocent family man in prison hasn't even raised a question by our media. I just saw an article that Brian Mayfield, a lawyer, imprisoned for 2 weeks as a terrorist, had received a $2 million settlement for his false arrest with no valid evidence. McMullin has been imprisoned falsely for approaching 150 weeks with no valid evidence. Will he be compensated $1 million per week? Perhaps if he was a lawyer instead of just a common family guy, our legal system would jump to his aid. How many other innocent people need to be imprisoned before our media investigates and the legal system responds with integrity? I predicted earlier that the accused would accuse another person, that the accuser would accuse another person of rape. This occurred much quicker than I expected. I now hate to predict that at some future date, Judge Jones, Judge Karabika, Attorney Goodman, Nurse Practitioner Smith, and DHS people will imprison another innocent victim with their witch-hunting approach to justice, and gunfire will erupt in some courtroom, law office, or DHS office. The media, police, and the public will then act astonished and wonder why. Rewatch this video and you will have your answer. As long as our court system remains controlled by arrogant, incompetent, and negligent people with no respect for right and wrong, we will continue to see large numbers of innocent people sent to prison. We need protection from this corrupted legal system. I hope we get it before more violence occurs. I have made another short YouTube of 2 imaginary cases which illustrate the injustice of Keith McMullin's imprisonment. YouTube, An American Tragedy, Richard Oehler, 2 Imaginary Cases, October 2015. Thank you again.